Hi, this is Professor Thaddeus Pope, and I just wanted to make a brief video in response to an email question that I got. And the question was based on some comments that I made about the Texas Advanced Directives Act. So the Texas Advanced Directives Act is a 21-year-old law that allows physicians, hospitals to withdraw or withhold life-sustaining medical treatment even when the patient or the patient's family want that life-sustaining treatment. So it allows clinicians and hospitals to make a judgment that the treatment would be inappropriate in their judgment. California has a very similar law. So I recently commented that because some appellate courts in the state of Texas have held that the Texas Advanced Directives Act is unconstitutional because it fails to afford adequate procedural due process protections to the patient, that California's law may be vulnerable to the same sorts of constitutional attacks. So the question was, well, the hospital didn't afford adequate notice of the review committee, so that's one of the problems. So the question was, well, how much notice is required? Well, the answer to that is actually relatively easily ascertainable because procedural due process questions do get litigated quite a bit, right? So people who suffer a deprivation of life or property may bring an action contesting that, and they may say that they didn't get sufficient due process. So it could be revocation of their driver's license or some other type of license, or some, anytime the state takes something away from you. And so we can look to that body of jurisprudence to get an idea about how much notice is constitutionally required before there's a deprivation. And here, of course, the consequences are life and death consequences. So arguably, we should look to instances where the consequences were similarly grave. Secondly, the question was the hospital didn't afford adequate opportunity to participate in its review of the treatment. And again, there's a pretty big body of procedural due process jurisprudence that we can look to get an idea about, well, how much opportunity should the family get to participate in a review when a hospital is going to unilaterally withhold or withdraw life-sustaining treatment. In fact, a lot of the relevant cases have been cited in the Tinsley Lewis versus Cook Children's Hospital litigation, and in prior Texas lawsuits that have contested the constitutionality of the Texas Advanced Directives Act. And then finally, the question that I got was the saying, this is one of the things I charged, is that the ethics committee lacked ascertainable standards for determining when treatment is medically appropriate. So that's another problem with the constitutionality of the Texas Act, and therefore I alleged, therefore probably also of the California probate code section, which is similar to the Texas Advanced Directives Act. Well, right now there's absolutely nothing, right, in the Texas law that says how the committee should reach a determination that treatment is inappropriate. And there are certainly ways to leave the committee a range of discretion to exercise their judgment, but also constrain that at the same time by saying what you should do is balance the burdens and the benefits and articulate, perhaps even as they do in the UK courts, a ledger. Well, these are the benefits of treatment, these are the burdens of treatment, and then come up with some articulation for why the burdens outweigh the benefits. And there's also ways to say you shouldn't consider stuff about the patient's, the value of their life as a member of society, how much they contribute to society. So you can put some guidance as to how the determination should be reached. And secondly, you can put constraints on things that should not be considered in reaching that determination. I should concede that the California law at least does have more specificity than the Texas statute by saying that the committee in a California hospital would reach a determination that, for example, what's being asked for would be, quote, contrary to generally accepted healthcare standards. So at least there's actually it's not super clear, but at least there is a standard that's identified in the California statute in a way that there's no standard specified in the Texas statute. So those are just some ways I think that a California hospital or even the California Hospital Association could take some lessons from the Texas litigation and shore up what they're doing as far as non-beneficial treatment policies to make them fairer, but also to make them more likely to withstand a challenge that they too are unconstitutional and that they fail to afford adequate procedural due process protections. Thank you.